system, and we're talking to the district judge for the Middle Tennessee District, Judge William J. Haynes. And of course, Judge Haynes, before we had our first commercial break, we indicated that we wanted you to talk about some additional things in reference to being a district judge in a real sense, and some of the things that many people might not be familiar with, and so that we can use this primarily as a teaching tool, and that's what we are concerned about this morning. Let's talk about judicial appointments. I think that all of us are familiar with these appointments being made by the president or somebody else, and et cetera, and we really don't understand the steps that are involved in it. So why don't you just sort of take us through some of the judicial appointments that that you think that we ought to be familiar with, some of the efforts in terms of making a judicial appointment.
Well, judicial appointments under the Constitution is reserved, is really an interreaction between the executive branch and the legislative branch. The Founding Fathers determined that for this branch of government that they would have an interdependence of political power. That is expressed in that the president has the authority under the Constitution to nominate judges for lifetime tenure, because with lifetime tenure it is a significant appointment. However, the Founding Fathers concluded that the United States Senate would have the authority to confirm nominees, to give advice and consent on whether this person should have a lifetime tenure. Because once you are vested in that office, you have life tenure, and you have the authority to, in fact, affect people's lives. And so the process involves a dual exercise of authority under the Constitution. As a practical matter, the appointment process may differ. For district judges, traditionally, if the president may consult with the senators of the state, who would sometimes set up commissions or otherwise identify persons that they would recommend to the president for nomination. Whether the senators or the president are of the same political party may have an impact on that. My experience in Tennessee is that there's been an excellent relationships and a bipartisan approach on the confirmation of federal judges. And so even though the president may be of one party and the senators of another party, there's been, in my experience, excellent cooperation. I was recommended by Vice President Gore, as I mentioned, but I had the enthusiastic support of Senator Frist and Senator Thompson that was a part of the Senate confirmation process. For the Court of Appeals, that may vary according to the president. The president may defer, again, to the senators, but because courts of appeals hear matters beyond one single state. For example, I mentioned to you the Sixth Circuit hears appeals from Tennessee, Kentucky, Ohio, and Michigan. So the president may feel that the executive branch should have more of a say in who the nominee should be, although because there is the advice and consent function, the senators will, in the process, will be consulted on whoever the person is being considered for the nomination. For the Supreme Court, of course, that's a national appointment, and it involves policy making on constitutional matters and receives appropriately very thorough scrutiny by the executive and the and the Senate. So that's how, in practical terms, my experience has shown the process works.
And of course, excuse me, but one of the, I would imagine, the greatest judicial appointment probably is a seat on the United States Supreme Court. Would that be a correct statement?
It is it's the highest level in the judicial branch of government, and has extraordinary responsibilities and duties, and would represent a very high honor. I think all of the judges, to have this level of confidence expressed by the Senate and by the President, I consider it a high honor to be a federal judicial officer.
And of course, Judge, you continue to talk about responsibilities, and I continue to talk about power. And I say that primarily because when we look at the judicial system and we see the judges making decisions and et cetera, it does seem that they exercise an awful lot of power, but you refer to that as a responsibility.
Well, judges can only act under the Constitution in cases where there's an actual case in controversy. And there are several prudential doctrines that courts have developed to impose restraints on themselves before we hear a case. When a case comes before us, assuming it's not a jury trial, the court can only must make findings of fact and conclusions of law. You can only consider factual matters that are admissible under the federal rules of evidence. In terms of conclusions of law, you have to apply the precedents of the Supreme Court and the law of the circuit in which you as a district judge reside. So I see those in terms of responsibility of making appropriate findings of fact, making sure that you are applying the law accurately as best you can to the facts that are before you. And I view that more in terms of a responsibility. But I don't want to overlook the fact that whatever the decision is, it can have a powerful impact upon people's lives because every case is important to the people and the parties involved in it. So I mean, it does have some consequence for persons. And
plus, all of these decisions are generally made because you understand that your peers are also looking over your shoulder. Would that be a correct assessment in terms of the law and et cetera? Perhaps some might even be second-guessing what your decisions.
Well, as a district judge, you're one judge deciding what evidence is to be admitted, and if it's a bench trial, then you're making findings of fact, or if it's a jury trial, you're admitting evidence. But our system is structured to have judicial review. I make mistakes in ruling on, may make a mistake in ruling on evidence, may make a mistake on findings of fact, or may make a mistake on the law. So the system is structured to get at the truth and to be as correct as we can in dispositions, and that's why you have higher courts. So, but my responsibility is to exercise my independent judgment, and that's what I try to do. And I think all the district judges do.
Very good. And of course, Judge, we're getting ready for our second commercial break, after which we'll come back and give you an opportunity to talk about that situation from a practical point of view in terms of some of the history of race relations in this country.
All right.
And we'll be back. U.S. District Judge